this one more time. The more I'm studying this, the more it's just coming more and more clear. I'm gonna have to walk out through some of this so that you can really, really get it. So that we all can really, really get it. Okay? I want to start at the beginning to show y'all that anytime you're in court, this is what they're doing to us, y'all. They administer your estate based on the premises that you are actually dead, because the probate court has no proof in their records, no petitions filed proving that you're not dead. Okay? I'm gonna start from the beginning so y'all can see this. First and foremost, I want to read to y'all what probate, what it actually means. Proof. Say to admit the will to proof, to admit a will to prove. Say to administer a decedent's estate, to grant probation to a criminal, to reduce a sentence by means of probation. You notice they're dealing with bodies, y'all. Notice that, right? That's why I wanted to read this part. Okay, talking about the will of a man or a woman who writes a will. Say the administer of a decedent, that's somebody who died. That's a body. Okay. To grant probation to a criminal, that's gonna be a body. They put criminals in jail, right? They gotta get the body to put them in jail. They don't put straw man in jail. Okay. It's on paper, yes, in jail, but they got the body that's in jail. Okay. To reduce a sentence by means of probation. Y'all know this is all dealing with jail. Probably bodies. I'm gonna say bodies, okay? Not jail, but bodies. In some cases, it's jail, but you get the gist of what I mean by when I'm looking at probate. Let's see. As a matter of fact, let's go a little deeper. Probate court. They say see court. I want to do that, but I'll probably do that in a minute. But let me see what this is gonna say. Probate estate. A decedent's property. Notice they keep saying a decedent. A decedent is somebody that's dead, okay? Dead or presumed to be dead. So understand that. A decedent's property, because a lot of people, they quit to say that they killed you or they made you dead. When they didn't make you dead, okay? People saying that, they kind of flow with it for the sake of, I guess they teaching you to make it, they don't explain the process of how you end up like that. How they create that status for you like that. And it all started with the Cesta KV Act of 1666. Say I'm gonna use an example. My father has property in Florida. Okay. He has land in Florida. He actually had, a mobile home on it, but they probably tore that down by now. But he has land in Florida. Okay. And he's been living with me for the last 2.5 years. I've been his caregiver, okay, for the last 2.5 years. And he will not be returning back to that land. But and I'll be taking care of the situation concerning that land. I have power of attorney to do that. Now, say if I didn't have power of attorney, or just say I didn't do anything with the land, I just left it there. After 7 years, they don't know what to do with this land. They know who's on their records as the owner, but they don't know what to do. So somebody's interested in this land 7 years from now, maybe say in 8 years, and they we don't know where so and so is. They don't know where my father is. They have no way of getting in touch with him. They haven't heard from him. So they don't know what to do with his estate. So in order for them to be legally able to allow someone to lay claims to this estate, this abandoned property at that point, then they have to declare him dead and then appoint an administrator, to probate the land, to probate the estate, because at that point they got to presume him dead. They did this years ago. They've been doing this for years. That's why the Cesta KV Act was written in 1666. They've been doing this for years. So people who leave there, they abandon their estate They made for whatever reason. They used to presume the lifespan of a man to be 70 years. But then eventually they had to decrease it because that's a long time to wait for somebody to come back who just may or may not come back. What if they died with it before 70 years? So they had to decrease it. And eventually they got down to 7. Now here in Georgia, it's 4 years. I think in Florida, I think it's 5 years. In North Carolina, South Carolina, one of them, I think it's 5 years. Anyways, it varies in different states. But here in Georgia, it's 4 years. Okay? So that's the little background when it comes to that. So they declare you, they assume maybe he's dead. He's not here. He hasn't showed up. He hadn't come back to claim to show that brought any proof that he's alive. His loved ones haven't heard from him. They don't know where he is. They don't know how to get in touch with him. So we have to declare him dead after so many years. And that's exactly what they do. But now I think they're just kind of going overboard now, because if you show up in a courtroom, you and your living status walk and stand before a judge, and they still make a damn judgment call as if you're dead, and you standing in front of them looking him in his fucking eyes. I don't understand how they allow that type of fraud to take place. Okay, but anyway, on the records in probate court, they have them as the administrator. That's why you find judges being administrators. They say there are no real judges, but there are real judges. They are, in the civil courts, they're administrators. They're administering your estate as if you are a decedent. Okay. Let's see. I'm gonna prove what I'm saying as I read the Georgia statutes to show you what I'm talking about. A decedent's property subject to administration by a personal representative. That's the judge right there. Okay. So that's probate estate. That's what they mean by probate estate. Say the probate estate comprises property. The probate estate comprises property owned by the decedent at the time of the death, and the property acquired by the decedent's estate at or after the time of his of death. Let's see. So I'm gonna pause on that part because I'm not gonna go any further with this part. I want to kind of get y'all a probate judge. Probate law. Let me see what this says right here. Let me show y'all what this is. Probate law. The body of statutes, rules, cases, etc., governing all subjects over which the probate court has jurisdiction. Probate court is that's the cornerstone where all these courts derive from. They're all dealing with estates. All of them are dealing with people's estates. And this is why they're able to do what they're doing in these certain levels of jurisdiction. When they're dealing with this straw man in civil court, this straw man is your estate. It's the Sesticate Trust, and they have what they call here in Georgia letters of administration that they've actually issued to these administrators to probate, which give them power and authority to administer your estate. Okay, and put in judgment calls as if you are dead. Or at their own discretion of what they choose to do. This is how they do it because they have power that was granted to them by the probate court. Okay, let me see. Probate. This is as you can see, you probably can't see that. This 1933 Black's Law Dictionary. What I showed you a minute ago, I think that was 2009 Black's Law Dictionary. But this is 1933. It says originally relating to proof, afterwards relating to the proof of wills. So originally this is what it is basically talking about, proof. This is where all the evidence is supposed to be at in probate court. This is where all the authority is granted to the officials based on the evidence that they have on file. The act or process of proving a will. Okay, this is a case law right here. The proof before any ordinary surrogate register or other duly authorized person that the document produced before him before him for official recognition and registration, and alleged to be the last will and testament of a certain deceased person as such in reality. Okay, again, they're presuming you to be dead. They can't administer your estate unless you have that dead status. unless you either have death status, presumption of death, or either established death. One of the two. They're going to go with a presumption or established death. So if you're dead in real life, they probate your estate. If you're presumed to be dead, they do administrating of your estate. Y'all get what I'm talking about. But they distribute your property, all your stuff, according to whatever will you got on whatever, or got on file, whatever you petition the court with the will. But anyway, let's go to the statutes. This is the beginning right here. This is where I actually started. It actually goes a little deeper than this, but I'm gonna see if I can actually go. I'm gonna even get into the father and mother aspect of this as well. Okay, because I found that it's in another title. It's in Title 29, but I'm gonna start right here. Okay. Now it says a domiciliary of this state who has been missing from the last known place of domicile for a continuous period of 4 years, so it's 4 years here in Georgia, shall be presumed to have died, provided, however, that such presumption of death may be rebutted by proof. Okay, the date of death is presumed to be the end of 4 years, unless it is proved that by preponderance of evidence that the death occurred earlier than that. Okay, so they're gonna presume that they died at the end of 4 years, unless they died before 4 years. Then you got some proof for that, then we'll take that too. But after 4 years, if we have no proof that he's alive, he or she is alive, we're gonna presume that they're dead after 4 years here in Georgia. When any domiciliary of this state has been missing from the last known place of domicile for a continuous period of 12 months or more, the death of the individual may be proved by a preponderance of evidence. So if you've been gone for a year, anyway, that's if you last known. Anyway, y'all need that explained. Notwithstanding any proof of the date of death that is earlier than the end of 4 year period set out in subsection A of this code section, the missing individual shall be deemed to have predeceased any other individual, deemed to have predeceased any other individual who has died prior to the date any petition for letters or other action on the missing individual's estate is filed, and from whom the missing individual would have taken an interest in property as an heir or beneficiary or otherwise. So when a domiciliary of this state has been exposed to a specific peril or tragedy resulting resulting in probable death, say some type of maybe an earthquake or something like that, Anyway, a peril or tragedy, the death of the individual may be proved by clear and convincing evidence at any time after such exposure. Okay, that is 53-9-1. We're gonna go to 2 now. Okay, 53-9-2. It says filing and contents of petition, publication of citation, a petition for administration of estates for the probate in common form or solemn form. If you understand what we mean by these things first, common form. Let's see, form belonging to a species, a form of probate. Okay, a form of probate of a will where the will is not contested. Okay, it's not contested and is proved by the executor's own oath. Okay, that's what they mean by common form. Solemn form. Proving the form, let's see. let's see. Proving a will in common form is how you prove that your will is real and properly prepared. Okay. While proving a will in solemn form is how you affirm the validity of a will in front of the courts. Okay, that's when you do it in open. Okay, just like you say a solemn oath, something you speak in before the court. The difference between column and solemn form probate is that the common form relates to a non-contentious proceeding, and solemn form relates to contentious proceedings. So you got somebody in there, two people, you got other parties in there going at it about it. So, okay, just want to get back to it. Say for years support. Let's see, a petition for administration of estate. Okay. And see for probate in common form or solemn form of a will, for a year's support, or for an order. See, keep in mind the word or. See, if you're trying to do a petition for administration of an estate, for this here, for a year's support, or for an order that no administration is necessary, may be filed for the estate of the missing individual, whose death may be presumed or established. See, that's you. If you're watching this video, this is you. You're presumed, your death is presumed, may be presumed. Established, you wouldn't be watching this video. Okay, in probate court, as provided in Code Section 53-9-1. That's where we just came from. The petition may be made by anyone who would be entitled to such a petition on the estate of the missing individual, if the missing individual were known to be dead, and shall be filed in the county in which the estate of the missing individual would be administering, were the missing individual were known to be dead. Okay. Make sure I ain't messing that up. Let's see. Filed in the county in which the estate of the missing individual would be administered, were the missing individual known to be dead. Okay. Let's see. In addition to complying with all of the requirements for petition pertaining to the administration of an estate or probate of a will or year support, or an order that no administration is necessary, as appropriate, the petition regarding the estate of a missing individual who is believed to be dead shall set forth the circumstances under which the individual disappeared, what inquiry has been made as to the individual's whereabouts, and such evidence as shall be offered if necessary for the purpose of proving death by a preponderance of evidence. Okay. For effective date, see note. Yeah, effective date. Just the date you're talking about. I don't see no other notes. Okay. If the court find the petition to be in compliance with the requirements set forth in subsection B up here of this code section, the court shall issue an order directing that a citation issue and be published once a week for 4 weeks in the official newspaper of the county in which the petition is made, giving notice that on a date certain, which shall be at least 90 days after the first publication of such citation, evidence will be heard by the court concerning the alleged absence of the individual presumed to be dead, and the circumstances and duration of such absence, and requiring the missing individual, if alive, or any other person to produce the produce and present to the court evidence that the missing individual is still alive. So they put it in the newspaper, and if you don't prove that you're alive by answering that publication, then they're gonna put in a order that you actually dead. So basically, the same way they do y'all in court. When like say if they do a service by publication, put it in the newspaper, and you don't answer it, you don't file an answer in that courtroom, they're gonna go with the presumption. Okay, they're gonna go with the presumption that you agree to what they're saying about you. The publication of citation requires by this subsection may be combined with any other service of notice required for the issuance of letters testamentary or letters of administration and an order for your support or an order that no administration is necessary or directed by the court pursuant to Code Section 5311-5. Did I even look at that one? Let me see. Let me click on that real quick. I probably ain't gonna read the whole thing. Cut that out of here real quick. Probate judge may direct any individual, any additional service or notice or extend the time to respond with respect to any proceeding covered by this chapter, as the judge may determine to be proper in the interest of due process and reasonable opportunity for any party or interest to be heard. That's why my damn court case been sitting there for 3 years. They never shut my case down. He extended the time to respond with respect to any proceeding covered by this chapter. Cause I'm thinking out loud, y'all, but the thing is, 3 years ago, I did open up a petition for a writ of habeas corpus, but I didn't do the shit right. I didn't do it properly. Like, I'm thinking it operates the same way as a civil case. When you get them served, you get the county, you get the process server to go serve them, and then they got to answer it once they get served. The same way they do y'all with the child support cases, and they got to answer it, and they got to answer it and show up to court and whatever. And this is what I thought I'm wondering why my case is just sitting there. Because I had her served, at least I thought I had her served, but I found out later, with about maybe 3 weeks ago, that she was never served, and that's mainly because she kept moving. I couldn't, the location that I thought she was living at, she was no longer living there no more. So now I know where she lives because I got the deed to the house she's living in. So just being diligent on the research. Now the thing is, she was, but the thing is, the case been sitting there, and that was 3 years ago. Generally, if there's no movement on the case, they'll shut it down. They'll just close it, like they did my child support case. Once they realized they weren't gonna get no compliance from me, I kept objection. I filed objection in the case repeatedly. So I kept on. I stood on it, and so they knew they couldn't get no compliance, no check stubs, no social security number, no agreement. Constant objections. I wouldn't let him call me Mr. Roseman. But so they got that from me, and eventually they stopped bothering me. And it took sat abandoned for years. And eventually, I think it was like 2019 when they finally dismissed the damn case. But nobody bothered me for that starting from the summer of 2017. Keep in mind, it started in September of 2016, and we were going back and forth with this paper war for almost 10 months, somewhere up in like June, July. And then I didn't hear nothing from them no more. They stopped bothering me altogether. Now here it is, me trying to get some justice. I'm opening up my own cases, thinking I can move by opening up a case because I didn't want to sit still on it. I want to get my boy back. So, but eventually I moved. I ended up opening up a different case. So I got 2 different cases opening up about this chick, over the years. So after I opened my case up, it was a different case, a regular case, a civil case. Me trying to get my son back. I was not successful. And then I eventually learned about a habeas corpus, but I didn't learn it properly, how to properly execute one. How to really do it. So here I was using it the same way a civil case is operated, but that's not how you do it. That's not how you do that with a petition for a writ of habeas corpus. Well, keep in mind, probate court deals with these types of cases. Superior court will deal with them, but anyway, I don't want to try to explain it. I might mess it up. But anyway, habeas corpus deal with the living man and woman. You don't serve the other party, you serve the judge. You got to get it filed into the court case. I'm saying serve the judge, but I know you're supposed to file a petition. So maybe I'm filing it wrong. Maybe I'm filing it. I'm gonna read this and we're gonna learn together. The probate judge may direct any additional services. Okay, I read this part already. We're gonna go back. I just wanted to read this part and go back here. Now, such service of notice shall be made as provided in chapter 11 of this title on all individuals who would be heirs of the missing individual were known to be dead. Heirs if the missing individual were known to be dead. Okay. The order may also direct that the petitioner make a search for the missing individual and shall specify the manner in which the search will be conducted to ensure that, in light of the circumstances of the particular case, a diligent and reasonable effort has been made to locate the missing individual. The order may prescribe any method of search deemed by the judge to be adequate and appropriate, including but not limited to publishing notices in the newspaper in appropriate locations and making inquiry of governmental agencies and of the missing individuals, relatives, and friends, and at missing individuals' last place of abode and other appropriate places. Okay, so basically, you got to look for them, see if they just before we can actually, we're gonna go with this presumption that person is dead. That's for somebody's whatever, This is in cases of there are people that actually have loved ones that really do think they're dead. Okay, now check this out. This is the part that made me start doing this damn recording right here. At any time after the entering of the order finding the missing individual to be dead, the probate court shall issue letters of administration or letters testamentary or an order granting years support, or an order that no administration is necessary in formality with all of the requirements of the laws in this state on the estate of the missing individual, and such letters or order, unless revoked, and all acts done pursuant thereof in reliance on such letters or orders, shall be valid as if the missing individual were known to be dead. So they are making judgments as if you're dead, period, because you have nothing. Nothing has been revoked. Nothing has been revoked. What they have said, they've made this diligent search for you. They don't know, they so-called made a search. At least they front like they do. And they proved it. And since you've been missing for the last 4 years with no evidence on the record that you're actually alive, that's when they issue those letters of administration and all this different stuff. Letters testamentary, ordering granting years support. In order that no administration is necessary in formality with the requirements of the appropriate laws of the state. On the estate of the missing individual. That's you. That's us. Okay. In such letters or orders, there's a child support order, unless revoked. I keep saying child support because most of y'all that call me dealing with child support, but this applies to anybody with any type of situation you got going on, and wondering why the judge is able to railroad you the way they railroad you, because they've been issued these letters, and because there's no proof on there in the probate court that you're not dead. They're gonna issue unless revoked all acts done in pursuant thereof, in reliance of such letters these letters of administration, the letters testamentary. Okay. Such letters in order or order shall be valid as if the missing individual were known to be dead. Okay. Now let's go to number 5. Number 5 is my favorite part, but I'm gonna make sure I get it right. Upon petition. I read this to y'all in a previous video. Now, upon petition of the missing individual, the probate court shall revoke the letters of administration or letters testamentary at any time on due and satisfactory proof that the missing individual is in fact alive. You know what? I'm sitting here wondering if I can do this shit properly. Doing it, I'm gonna take a chance and I'm gonna go out on a limb and get my evidence, and I'm gonna just file it into my damn court case, into my habeas corpus court case. It's a habeas corpus case. I'm gonna file it in there, and I'm gonna send a certified copy to the judge. Not a certified copy, but I'm gonna send a copy of the filing, a file stamp copy to the judge, so that he know that this has been done. It's gonna be a petition with evidence attached to it. I have it already typed out, and I got certified copies of evidence. What type of evidence can you use? Medical records. You can use that. Certified copies. Okay? Certified copies of medical records. You don't have none, go get some. Make sure they updated. Okay? That's what I'm using. Okay? Certified records. You can actually use anything that to prove. You can use affidavits to prove that you're alive. Affidavits of, according to a maxim of law, every word should be established by 2 or 3 witnesses. 2 or more witnesses. That's actual scripture as well. Use affidavits. But I would use you could use anything. Anything. Well, I can't say anything. You need to make sure it's something that only a living man can have. That's why I think a medical record is like the best thing you can goddamn use. Especially if you're giving blood work and stuff like that. If you're crazy enough to go get that flu shot, you can go get that. You can get that medical record. That can prove that you're alive. I almost said something smart, but you get it. Cause I'm so anti-vaccine. I'm so anti-vaccine. I ain't going front. But if you got the jab, you can go get a certified copy of that record, that proof that you actually you got that, and you can use that because that's proof that you're actually alive. And I have it with your petition. Put it with your petition. They also have a standard form. I'm gonna show y'all something. I'm gonna finish reading this first. Let's see. After such, it say, okay, I'm gonna read this again. Upon petition of the missing individual, that's your petition, the probate court shall revoke the letters of administration or letters testamentary at any time on due and satisfactory proof that the missing individual is in fact alive. Okay. After such revocation, all powers of the personal representative shall cease, but all receipts or disbursements of assets or other acts previously done by the personal representative shall remain valid, and the personal representative shall settle and account for the administration to the time of such revocation, and shall transfer all assets remaining to the missing individual or such individual's duly authorized agent or attorney. If you got somebody to represent you, then you can do that. You can have they'll give it to them. But me myself, I don't use attorneys. But maybe for a case like this, maybe you can. I don't know. I just don't trust them jokers. So I do my own stuff. So maybe I'm traumatized. Pardon my ways when it comes to attorneys. Okay. Now, recovery of property. At any time before the expiration of 2 years after letters or in order for year support, or in order that no letter of administration is necessary, is due regarding the estate of a missing individual, any property received by any spouse or child or other purported purported heir or beneficiary of the missing individual may be recovered by the missing individual unless the property has been transferred for an adequate consideration to a bona fide purchaser. In which case, the amount of the consideration received for such transfer may be recovered from the transferor. No action to recover any property from any spouse, child, or other purported heir or beneficiary, or to recover any consideration received by such a person as a result of transfer of property to a bona fide purchaser may be brought by a missing person individual after the expiration date of 2 years, a 2-year period set out in the code section, unless the missing individual is a minor, in which case the time for bringing such action shall be extended to 2 years from the date the missing individual reaches the age of majority. Okay, so that's recouping all your property or whatever after you've been proven to be alive. Okay, 6. Let's see. Distribution of assets. Judges allowed to hold certain funds and missing heir. This is actually when somebody's actually dead or whatever. It's something else I want to show y'all concerning. Let's see. This is something else they do. This is the. I just love this part right here. I just like this part here. I read it every day now, so it's in my system now. So it ain't going nowhere. Let me see what we got here. No, I ain't talking about voting. This ain't what I'm talking about. I was just looking for something then. I think this was it too. I was looking for that too. Okay. I was just reading that. It was something else. Let's see. Should I just end this right now? Yeah, I'm going to end it. I'm going to say that for another video. That's what I'll do. I'll save it for another video because I think I've been going long enough. This damn video, this thing is 37 minutes long. But I just have to make sure that y'all are getting this about probate court. This is where your remedy is it's in probate court. Don't get me wrong. See, we dealing with trust laws as well. We dealing with trust, but at the same time, you want their records to be straight when it comes. This is the reason what made me look deeper into this. And I'm gonna wrap this up because we ain't got this thing 37 minutes long. I gotta wrap this up. But this is the reason why I went deeper, because when I created a trust and I went and got an EIN number for my trust, and I'm sitting here, that's on the IRS website, and the IRS asks who's the trustee. Of course, I put my name on there, but keep in mind the IRS only deals with entities. They don't deal with living men and women. So you saying you're appointing yourself as a trustee, but you got to put the straw man's name there, and automatically it asks you for the social security number, which means it ain't talking about you. It's talking about the Cesta K Trust. So what you're doing is making the Cesta K Trust the trustee of your revocable living trust or irrevocable living trust, whichever one you chose to do. But you're really making the Cesta K Trust the trustee of your living trust. So I'm like, and then we stuck on these debates about becoming a national and as opposed to a U.S. citizen. Those are titles that actually go to the Cesta K Trust. None of these titles apply to a living man. Okay, none of these titles apply to a living man. You're not a national. It's the status of the name. The name is a U.S. citizen. It's considered a U.S. citizen. You're trying to change the status of the U.S. citizen, the Cesta K Trust from U.S. citizen to national. And then you still want to attach your body to it as if you, the living man, or living woman, is a national. Keep in mind those titles apply to the Cesta K Trust. Okay, so. But it goes even deeper. You're taking it a step further when you want to be. You're saying you're a living man? Prove it. You say you're a living woman? Prove it. How you gonna prove it? You're gonna prove it in probate. That's how you prove you're alive. That's what we talking about right here. You're missing right there. Prove it. Okay? You just got to prove it. So when you prove you're alive, that kills all that. It kills the straw man fight altogether. And it says all the assets, all the property goes to you. Everything goes to you. Now you're alive. Okay? It don't make you alive because you change the straw man status to a national. You know, you still considered dead in the probate court. You know what I'm saying? You as a living man, as a living woman. So probate is where it's at when you're talking about proving that you are alive. Okay? Emeralds, signing out.